A lawsuit brought by former Assistant Superintendent of Student Services, Dr. Richard McAlindin, was a contributing factor leading to 7 administrators being placed on paid leave pending an investigation. McAlindin's position oversaw student services, including student discipline and site guidance, a process involving a team of district counselors, school administrators, and even students' families to help support students with more serious disciplinary issues and prevent them from engaging in those behaviors. By removing site guidance, discipline worsens, classroom instruction is negatively impacted, and assaults on students and staff increase. According to the suit, around November 15, 2023, Chernas sent emails to individual principals regarding student discipline without informing McAlindin. On November 16th, Chernas directed Renee Gray, currently serving as interim superintendent, to email all principals informing them that any suspensions of special education or SPED students would no longer go through site guidance, but through Dr. Gray, then in charge of SPED. McAlindin was excluded from these emails as well. This meant those students would no longer be receiving support to help them avoid serious disciplinary issues, which could and did persist on campuses. Later that afternoon, McAlindin met with Dr. Isaac Gates expressing concern Chernas was excluding McAlindin from emails and decision-making McAlindin oversaw. According to the complaint, on November 27th, McAlindin met with Chernas and asked him to include him in his decision, quote, so he would know about, understand, support, and implement them. Chernas agreed and shook McAlindin's hand. 3 days later, McAlindin attended an elementary principals meeting in which he states Chernas told principals he, quote, did not care if a student hits, kicks, or punches a staff member. It's part of their job, and it's your job as principals to make them understand that. Think about that. According to McAlindin, Chernas was instructing principals to return to their schools and convince their staffs that being assaulted was part of their jobs. We wonder if Alex believes district personnel and his executive staff should be assaulted as part of their jobs. Probably not. On December 6th, McAlindin brought his concerns to Gates and Nancy Blade, Director of Human Resources. Concerned Chernas' policy permitted physical violence against staff members and violated collective bargaining agreements and laws regarding employee safety. That same day, Gates, Blade, and David Huff, the district's legal counsel, met with McAlindin to inform them that the district was going in a different direction without him. Huff also discussed payout terms on McAlindin's contract, which stated he was either to be notified of reasons for termination if he was being fired for cause, in which case he could respond to the board with legal representation paid by himself. Otherwise, if he was being let go without cause or a hearing, the district was supposed to give him 45 days' notice and pay him a lump sum equal to the remainder of his contract or an amount equal to 12 months' salary, whichever amount was less. This claim also explains why Huff is conflicted because he can't represent the district in this suit as he could be a witness or possibly a defendant to be named later, and why it was necessary to hire another firm in the emergency board meeting back on December 19th. On December 7th, Chernas met with McAlindin stating the board refused to pay what McAlindin was owed. McAlindin also accuses the district of allowing Chernas to attempt to dig up information to damage McAlindin's reputation and make up, quote-unquote, cause for his termination to avoid paying him what he was owed. Quote, including but not limited to Chernas having McAlindin's colleagues interviewed and his emails and communications scrutinized for any breach of contract. This supposed fishing expedition led McAlindin to suffer mental distress, sleeplessness, anxiety, and other physical symptoms. For example, McAlindin alleges on December 12th that Chernas' retaliation efforts caused him a medical emergency including severe chest pain, heart palpitations, sweating, and dizziness, forcing McAlindin to take medical leave. Despite the scrutiny, McAlindin was never informed of such a breach on his part. On January 16, 2024, while still out on medical leave, McAlindin's position was filled by Renee Gray, with the board's approval. His suit accuses the district of allowing, quote, working conditions to exist that were so intolerable that left McAlindin no choice but to eventually resign. He also alleges that his requests for communication and reports of a hostile work environment were ignored. Although he wanted to continue in PYLUSD, McAlindin sought employment elsewhere and on May 2, 2024, submitted his resignation under constructive discharge, which, according to the California Supreme Court, is when, quote, the employer's conduct effectively forces an employee to resign. He filed a claim for his unpaid wages with the district on May 10th, but was denied without explanation. Through this suit, he's seeking a jury trial to recover unpaid wages of at least $228,000 plus additional damages and attorney's fees. This suit also raises questions about the motive for amending the contracts of Chernus, Gates, Young, and Gray in November of last year. This complaint was filed on November 4th and specifically names 3 executives whose contracts were amended. In addition, Dr. Young is one of the executives also currently on paid leave. Did the outgoing majority use information from this lawsuit to change these contracts with the knowledge that some of these employees may be involved in potentially illegal activity? In other words, they could be fired for cause. There sure seems to be a lot of smoke. Hopefully, with the amended complaint, we'll get to see the fire.